Hello and welcome back to the channel. In this mini lecture, we're looking at the tort of defamation, an area of law that protects a person's reputation, but inevitably limits freedom of speech. So on this slide, I've just given you a few examples of recent, very high-profile defamation cases. You'll all remember the case of Johnny Depp versus Amber Heard, which was actually held, or there were two trials, one in the United Kingdom against a newspaper and one in the United States against Ms. Heard herself. And closer to home, there was the so-called Agatha Christie case, where Rebecca Vardy sued Colleen Rooney in defamation. We're not going to look at these cases in a lot of detail, but do go and have a look and see what happened in those cases. Now, defamation is a tort that I personally find very interesting, and I do discuss the Depp case in a little bit more detail in the book that I happened to write on this. So I even published a book, here you've got it on this slide, comparing the defamation law of England and Wales to those of the United States and Germany. So this book was published in 2024, and I'll post a link in the description below in case you're interested, or in case you happen to be a law student and you can recommend the book to your law librarian at your university. Now, you'll notice that I have split discussion of defamation into two lectures. The second lecture will deal with the defenses, whereas this lecture deals with the claim itself. The reason for two lectures is because, unlike other torts, much of the heavy lifting in courts actually fall on the shoulders of the defendant. For instance, did you know that in the Defamation Act 2013 itself, only a single section, Section 1, deals with the claimant's burden, whereas most of the rest of the Act is devoted to the defamation defenses? For that reason, make sure that you also watch the separate video that I'll post on the defenses to defamation. But let's start looking at the tort itself and what the defamation claimant needs to prove. The key point to understand is that defamation strikes a balance between two competing values. On the one hand, the individual's right to reputation, and on the other, society's interest in free expression. We'll explore both as we go, and later I'll discuss why Parliament felt the need for reform through the Defamation Act 2013. On this slide, you can see the distinction between libel and slander. Libel covers statements in permanent form. This would be, for example, things that are written down, printed, filmed, or even depicted in statues. Up until 2014, it used to be actionable per se, meaning harm was presumed. Now you need to prove serious harm to reputation in libel cases. By contrast, slander involves transient forms like spoken words or gestures. Most slander cases require proof of actual loss, unless they fall into one of a few exceptions. So you can think of libel as fixed and lasting, whereas slander is fleeting but potentially just as damaging. Now, usually today, most defamation cases will concern libel because everybody's got one of these and everybody seems to be recording everything, which means things are more likely to be captured in permanent form now than to be fleeting or not lasting. So what is defamation? Here we have a classic definition. Defamation is the publication of a statement that harms the claimant's reputation in the eyes of reasonable members of society. The phrase here, right-thinking members of society, comes up often. It doesn't mean right-wing people, it means the ordinary reasonable reader or listener, not somebody that is unusually sensitive or biased. So what matters is how the public would see the claimant, not how the claimant feels personally. As you can see on this slide, another way to define a defamatory statement is to ask what effect it has on the listener. Would an ordinary reasonable person think less of the claimant, doubt their competence, avoid them, or ridicule them? If so, the statement is defamatory. It's about perception, what others would think after hearing or reading the statement. There are 4 elements a defamation claimant must prove. First, that the statement was defamatory. Second, that it referred to the claimant. Third, that it was published to someone else. And finally, that it caused or was likely to cause serious harm to the claimant's reputation. We'll go through each element step by step. Let's start with the first element, that a statement must be defamatory. As shown here, a statement is defamatory if it tends to lower a person in the estimation of others. It's about how the claimant is viewed by society, not about hurt feelings or subjective embarrassment. Reputation is a social construct. It exists in the minds of others, and it can change over time. What we regard to be defamatory today is not necessarily the same as what people in 1910 regarded to be defamatory. Reputation, therefore, is a social construct. It exists in the minds of others, and it focuses on public perception. Now, as you can see, not all defamatory meanings are obvious. Some words, such as, for example, liar or thief, are clearly defamatory. Others may only become defamatory through implication or innuendo. In law, we speak about a true innuendo, which relies on special knowledge. For example, slang, things that certain people, for example, street language, would understand because they are members of the group that use that kind of slang, will not be necessarily clearly defamatory to other people who do not use that specific meanings of the words. So for that, the court needs to be informed about what the slang meaning of the word is if you are relying on that as being defamatory. A false innuendo, on the other hand, arises where the words themselves look harmless, but if you happen to have insider information, you will realize that there is a hidden meaning. For example, if a sentence reads as follows: X was seen kissing Y passionately. On the face of it, this is not a harmful statement, but if you happen to know that X is the 52-year-old teacher of Y, who is a 14-year-old student, then the words take on a more sinister meaning. So the courts look very carefully at what the words would mean to an ordinary reader in context. The element that the claimant needs to prove that the statement was defamatory requires the claimant to actually prove two things. First, the meaning of the statement complained of, and secondly, that this meaning was defamatory. Now, whereas in the common law, it used to be that the jury decided both what the statement meant and also whether it was defamatory, since the Defamation Act came into operation in 2014, it's now become the job of the trial judge, because the Defamation Act basically did away with jury trials. So it's now become standard practice in defamation claims to have a trial before the actual trial of preliminary issues at which the court, in other words, the judge, determines the natural and ordinary single meaning of the words complained of, and also to what extent the words were a statement of fact or an expression of opinion, and to what extent they were actually defamatory. So first off, the hearing will determine the meaning of the words. In defamation law, there can only be one natural and ordinary meaning of a statement, which the court has to identify. This is known as the single meaning rule. In the case Kutso-Giannis versus the Random House Group Limited, the court had to determine the defamatory meaning of passages in a book called The Spider Network. And I give you a picture of that book here. Now, this book was written about the Libel scandal, which Libel refers to the interbank lending rules. And this was a scandal about rigging bank rates. The book itself referred to the claimant, who had held a senior position with an investment bank at the time, and he then sued them in libel. Go and have a read of the case to see what was decided there. But what is important for us from the case of Kutso-Giannis is that Judge Nicklin explained the single meaning rule as follows. The court's task is to determine the single natural and ordinary meaning of the words complained of. Now, this is the meaning that the hypothetical reasonable reader would understand the words to mean. It's an objective test, very similar to the reasonable man test, the reasonable person test used in negligence claims. Nicklin J. summarized from the common law the following key principles to aid the hypothetical reasonable reader's determination of the meaning of the words. Firstly, the governing principle is reasonableness. Then, the intention of the publisher is irrelevant. There's no fault element in defamation. Then, The hypothetical reasonable reader is not naive, but also not unduly suspicious. They can read between the lines and may indulge in a certain amount of loose thinking, but is not avid for scandal, and does not and should not select one bad meaning where other non-defamatory meanings are available. Then, over-elaborate analysis must be avoided. So you're not going to hunt for a meaning, you're not going to analyze too much. Further, the court should not take a too literal approach to the task and should not fall into the trap of conducting too detailed an analysis. It's not enough that some person or another might understand the words as being defamatory. The publication as a whole must be read, and it must be read in context. Now, a good example of the way that meaning is now determined in defamation trials was the Supreme Court's judgment in the case of Stocker versus Stocker, where the defendant's ex-wife said this to her ex-husband's new partner in a Facebook post. "He tried to strangle me." The issue before the court was purely that of meaning of that sentence, "He tried to strangle me." The judge had to decide what those words would convey to the ordinary reasonable reader of a Facebook post. At first instance and on appeal, the words were given their dictionary definition, which agreed with the claimant's allegation that it meant, "He tried to kill me." Now, affirming the single meaning rule, the court emphasized that the primary role here was to focus on how the ordinary reasonable reader would construe the words in the event of several possible meanings. The court found that the ordinary reader of a Facebook post would unquestionably have interpreted the post as meaning that the claimant had grasped the defendant by the throat and applied force to her neck, rather than trying deliberately to kill her. Now, because this was in fact what had happened, the court held that the appellant's defense of truth succeeded. She could actually prove that, yes, her husband did grab her by the throat and applied force to her neck. Moving on to the second element that the claimant needs to prove. This is that the statement has to identify the claimant. Here, the claimant therefore has to show that an ordinary reasonable person would take the statement as referring to the claimant. It doesn't matter if the defendant didn't intend to identify the claimant. As you can see from the case of E. Hulton and Company versus Jones in 1910, even accidental identification counts. In this case, the defendants published a humorous newspaper story of the discreditable behavior in Dieppe of a fictitious character called Artemis Jones. Now, unknown to the author or editor, there happened to be a real person called Artemis Jones. He differed in a few respects from the fictitious character, but some of his friends actually did think that the article referred to him. He therefore successfully sued the owners of the newspaper for libel. It didn't matter that the defendant did not intend to defame him. All that mattered was what a reasonable person would understand the words to mean. The test is therefore always how a reasonable reader or listener would interpret the statement and who they would think it referred to. The third element that the claimant needs to prove was that the statement was published. Now, publication simply means communication to someone other than the claimant or the defendant's spouse. This is shown on the slide with examples like Huth versus Huth and Thieker versus Richardson. In Huth versus Huth, 1915 case, a letter was sent in an unsealed envelope by the defendant to the claimant. The defendant's butler secretly read the letter without the claimant's permission. Now, this was not treated as publication, as the defendant could not have foreseen that the butler would open the letter, so he was not liable for defamation. By contrast, in Thieker versus Richardson, communication to a third party was foreseen by the defendant, and therefore it amounted to publication. The defendant had written a letter stating that the claimant was a lying, low-down, brothel-keeping whore and thief. He put the letter in a sealed envelope and posted it through the claimant's door. The claimant's husband then opened the envelope, and the defendant was held liable for defamation, as it was foreseeable for him that the letter might be opened by someone other than the claimant who happened to have the same name. The takeaway here is simple. If a third party reads or hears the statement, it's published. The final element to be proven by the claimant is that there was serious harm to their reputation or likely serious harm to the reputation. Before the Defamation Act 2013, in other words, in the common law, defamation was actionable per se, meaning that once you proved that the statement was defamatory, the court presumed that there was harm. You didn't need to prove that there was harm. However, under Section 1, subsection 1 of the 2013 Defamation Act, now a statement is not defamatory unless it has caused or is likely to cause serious harm to the claimant's reputation. This change was introduced to stop trivial claims and to focus on genuinely damaging publications. And the leading case here is that of Lashau versus Independent Print Limited, which was decided by the Supreme Court in 2022. I will post a link to the Supreme Court giving their judgment in this case, a video of the Supreme Court giving their judgment in this case in the description below. But let's look at this key case in a little bit more detail. Initially, there was some confusion in the courts over how the provision of Section 1 was intended to work. Did it just raise the bar for claimants but still keep the common law presumption of harm? Or did it mean that the presumption of harm no longer existed and claimants actually had to supply evidence that their reputation had been or was likely to be damaged before a claim could even be examined? The Supreme Court clarified that this was exactly what Section 1 meant in the case of Lashau. This case concerns serious allegation of, amongst others, things like domestic abuse and kidnapping of the couple's child made in a British newspaper against the claimant by his ex-wife. The meaning hearing was relatively straightforward and found that the allegations were indeed defamatory. You can think for yourself, allegations of kidnapping, domestic abuse, etc. They were defamatory. The next question, however, was whether the common law inference of harm should follow. In other words, under the common law, once you establish that the statement was defamatory, the court will then presume that your reputation was harmed. The court had to decide whether the claimant now faced an additional evidential hurdle in terms of Section 1(1). And the Supreme Court held that it was clearly intended in Section 1 to make a significant amendment to the common law. Not only is the threshold of seriousness raised, but proof is also now required on the fact that the impact of the words was to harm the claimant's reputation. So this means that it is now a matter of fact, and evidence has to be led about the impact which the statement actually makes. The Supreme Court also clarified that the term likely to cause in Section 1 in turn points to possible future harm, and that this too must be established as a fact. In short, the Supreme Court confirmed the demise of the common law presumption of harm, and it made the Section 1 serious harm requirement the most difficult hurdle for a defamation claimant to clear. Moving on from the 4 things that the claimant has to prove, let's look at a few other issues. In this slide, we just basically summarize who has standing to sue. Living individuals can bring a claim, as can companies, as well as certain office holders, such as individual members of government or individual members of political parties or individual politicians. However, relatives cannot sue over harm to a deceased person's reputation unless their own reputation is affected, in which case they will have to prove that it is their own reputation that is harmed. Government bodies as such and political parties as such cannot sue either. Now, this was established to protect open criticism of government. You'll notice that the 2013 Defamation Act added a significant hurdle to defamation claimants by requiring them to prove serious harm to reputation. That's not the end, though. It also made some very significant changes to the defenses available to a defamation claim, which we will look at in a separate video. It all adds up to making it much more difficult to succeed in a defamation claim now than under the common law prior to 2014. The question is, why did Parliament legislate to reform defamation law so much in 2013 through the 2013 Defamation Act? On this slide, I summarize for you various issues that make defamation unique, such as the fact that it has a very short prescription period, a more or less reverse burden of proof, and up to the reforms in 2013, it had the effect of chilling free speech in the UK or in England and Wales at least, because it was relatively easy for claimants to silence critics merely by threatening to sue them in defamation. The main problem in the common law was inequality of arms. Defamation cases were extremely expensive, and with no legal aid available to either party, powerful claimants could use litigation to silence critics. So access to justice became a serious issue, and public debate was being chilled. This was very clearly illustrated in the so-called Libel case, Steele and Morris versus the United Kingdom. Have a look at my tort law playlist in this channel, where you'll find an in-depth and very interesting documentary film on this case. As you can see here, Steele and Morris versus UK involved two activists that were sued by McDonald's in the United Kingdom. Now, their claim, the McDonald's versus Steele and Morris claim in the UK, was extraordinary. The two activists represented themselves in what became the longest trial in English history. There were about 20,000 pages of transcripts generated, and over 100 witnesses were called. It ended up being, like I said, the longest and probably one of the most expensive cases ever in English history. Now, although the activists lost their case, or lost in the UK case, that is, McDonald's won their defamation claim in the UK, the activists took the matter to the European Court of Human Rights, which ruled in their favour. It ruled that denying the defendants legal aid breached their Article 6 European Convention of Human Rights, a right to a fair trial. And this case illustrated how unfair and unbalanced defamation proceedings could be for ordinary defendants in the UK. Now, this is a crucial slide. Once the claimant proves the four elements, and even with the 2013 reform, it's still a fairly light burden of proof. So once the claimant proves the four elements for defamation, the burden then shifts to the defendant. The defendant then has to prove a defense, and there's a long list of possible defenses for defamation claims. Now, these defenses could be, for example, truth, honest opinion, privilege, or a publication on a matter of public interest. This reverse burden makes defamation unusual amongst torts because the claimant's job is relatively easy compared to the defendant's. Again, remember to also watch the lecture video on defamation defenses, which I'll post on my channel. Furthermore, before the reform in 2013, the UK had a real problem with something which was known as libel tourism, which meant that foreign claimants brought their matter to the United Kingdom because it was relatively easy to succeed here, even if the matter actually had more impact in another jurisdiction. So before 2013, foreign claimants often sued in London even when there was only a very minimal link to the UK, because English law was seen as being so claimant-friendly. The United States even passed an act called the Speech Act 2010. Here you can see President, as he was then, President Barack Obama, signing this act into law. And this act was designed to protect Americans from English judgments in defamation. A very famous example of libel tourism was the case of Bin Mahfouz versus Ehrenfeld, which concerned a matter where only 23 copies of a book were sold in the UK, yet the case was brought here. Now, the reforms to the common law in the 2013 Defamation Act sought to end the reputation of London as being the libel capital of the world, the England and Wales being the libel capital of the world. To wrap up, as you can see on this summary slide, the Defamation Act 2013 introduced major changes: a serious harm requirement, the single publication rule, stronger public interest defences, and limits on jurisdiction for foreign claims. So overall, the Act rebalanced the law in favour of free speech while keeping protection for reputation. Defamation, however, remains a delicate balance, protecting people's names without stifling open discussion. To conclude, defamation law has evolved from rigid common law principles into a modern framework that reflects democratic values and the realities of online communication. If you remember just one thing, let it be this: reputation matters, but so does free speech. And the law of defamation tries to balance those two conflicting rights. Thank you for watching, and if you found this helpful, Please like, subscribe, and check the next video for part 2, where we will explore the key defenses available under the Defamation Act 2013.